Hello, this is Matt on the Moon Lambo channel, and I've got just one story to share with you in this very latest Moon Lambo Hot Jam. And it's written by Kevin O'Brien, who is an attorney. And it has to do with the clear fact that Ripple's defense, their approach is, let's just say it's rather intense. And they've got a lot going for them. And Kevin O'Brien actually in this piece ends up pointing out that like what you got to do is just chip away at the SEC's credibility, which frankly isn't that hard to do if we're being for real, right? So here's what he titled his piece. Ripple's discovery wins over SEC offer defense strategies. And this is a piece that he wrote for Law 360. And so I've never highlighted anything from Kevin O'Brien before, but I enjoyed the piece and I thought that you would too. So I thought I'd run through it and share with you some thoughts along the way. But I do want to be clear at the outset. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. I am just an enthusiast who enjoys making YouTube videos purely as a hobby. That's all that's going on there. All right, so it begins as follows. The recent success of Ripple Labs, Inc. in gaining access to the U.S. Securities and Exchange Commission files, as well as the right to take testimony from a former agency director, could be a watershed moment in SEC enforcement actions. Oh, and by the way, I want to mention this too. We just got verification that for sure Hinman was deposed. He was questioned under oath. We found out just a couple days ago because Brad Garlinghouse, Ripple CEO, in the Aspen forum, which happened just the other day, he actually brought it up because the reason we know he didn't word it as William Hinman was deposed, and we already knew that he was scheduled to be speaking under oath. But he said, "Here's what William Hinman said under deposition." Basically, that's basically it. If that's not literally it, it's very, very close. And so that was the first actual indication from anybody in the know that for sure this happened. So that's a certainty at this point, which is good news. We all thought that it happened. Now we know for sure. Anyway, lawyers representing defendants sued by the SEC often seek internal evidence of staff decisions and thought processes, hoping to undermine the agency's public positions underpinning the complaint, but they almost never succeed. The reasons given for denying these requests are familiar. The SEC's representations and legal opinions stand or fall on their merits, without the need for any discovery, and its good faith, to the extent it might be relevant, should ordinarily be assumed. SEC vs. Ripple Labs now before the U.S. District Court for the Southern District of New York. The case, in which the SEC has taken on a leading blockchain technology company, breaks the mold. The question posed in the case is whether Ripple's digital token, XRP, is an investment contract and therefore a security under the federal securities laws. If the answer is anything other than yes, the SEC has no case and no jurisdiction to proceed. Back in February, at the first case status conference, both sides staked out aggressive discovery positions on this question. Ripple announced it was considering a motion, which it ultimately brought, to compel the SEC to produce documents reflecting internal discussions as well as discussions from third parties about whether the agency considered XRP sales to constitute an unregistered securities offering. And so let me pause right there. This is a strong defense. Now, for us lay people here just taking in the facts, seeing that the way in which the SEC has unevenly distributed justice over the last decade or so, and not just that, but like the inconsistency sometimes from case to case, it's very clear. And then the messaging that was coming out, and also lack of messaging at times as well. Like you throw everything together and you just think, how could it possibly be the case that a rational actor working at Ripple could possibly think that what they were doing was illegal in any capacity, that the SEC would not be okay with it? How could you possibly state that there actually was fair notice? Well, for an average unbiased person just taking in the facts, it's very clear that Ripple and other market participants have not had clarity. That's for damn sure. And you can make arguments on either side, but that's the point. The fact that you could make solid arguments based on various statements for the last decade That's exactly what I'm talking about. Like, there isn't clarity. And so if Ripple didn't have clarity, then the SEC doesn't have a leg to stand on. And so the way that this all works is if indeed in court Ripple's fair notice defense stand up this idea that they should have known better but didn't act as such, if that stands in court, then this whole thing's over. Which is why this is so powerful and so important, and that's what part of what Kevin O'Brien's getting at here is messaging and getting at personal opinions. As you'll see as we go through this, he dives in deeper. But anyway, let me continue. Excuse me. For its part, the SEC claimed it was entitled to legal memos that Ripple's leadership reportedly received, in which the company was warned these sales could in fact involve securities. The agency lost both battles. In June, U.S. Magistrate Judge Sarah Netburn, overseeing discovery in the case, denied the SEC's motion for access to the memos because they were protected by the attorney-client privilege. She specifically rejected the standard argument that the defendant had effectively waived the privilege by raising a reliance on counsel defense or in some other way putting its subjective state of mind in issue. As she clarified that Ripple's defense instead, according to its answer, was that the SEC had failed to provide fair notice to the market that XRP might be considered an investment contract. This defense, the court concluded, does not involve the company's own understanding about XRP's legal status. And that's a quote, by the way. That conclusion may or may not be correct. It can be argued either way, but Ripple's far-sighted pleading of the fair notice defense carried the day. In contrast, Ripple's bid for the SEC's internal files was successful despite the apparent odds. In April, ruling from the bench, Judge Netburn held that, as a general matter, SEC minutes and memos, quote, expressing the agency's interpretation or views, end quote, on XRP were discoverable, subject to specific arrangements between parties. Yeah, and so what they were talking about right there, just to pause for a moment, it's there are certain things, and this, to be fair, like look, let me word it this way: there can be instances where the SEC certainly can make legitimate privilege objections. Basically, they can present that. And certainly it's the case, that could be the case anyway, that in some of these documents that maybe ideally Ripple would like to have their hands on, it could be the case that there are certain things that should not get out, or at least portions of it should be redacted. Who knows? There can be legitimate claims right there. And so it's not that necessarily everything should go over, but yes, if there's any sort of topic, outside of those types of circumstances that gets at how high-ranking officials in particular at the SEC came to the conclusions they did about Bitcoin and Ethereum and XRP, that absolutely should be discoverable because it plays into this fair notice defense that Ripple has put out there, unquestionably. Right? Anyway, and then Kevin continues now. The court appeared to give credence to Ripple's... Yeah, there we go. Sorry, that wasn't the right spot. I thought I missed something. The court appeared to give credence to Ripple's complaints that the SEC had kept silent for 8 years before bringing suit, apparently unsure whether XRP was a security or not. The SEC, in allegedly keeping its doubts to itself, may have failed to provide fair notice. May have? I would say, like, from my perspective, 100% unquestionably. But I respect what he's saying there, but I'm just saying from my perspective, could not be more clear. I've been following this so closely every single day since this story broke. Actually, the day before the lawsuit, the story broke on December 21st when I think it may have been Brad Garlinghouse that came out and first stated that, hey, we're about to get sued by the SEC. And just taking in all of the facts, it's, oh my gosh, a reasonable market participant could not know for sure. And so then after time passes, you're just left to, if you're a business and want to operate in the space, eventually you got to pull the trigger and make a decision on various things. And so that's why, for instance, ultimately Coinbase did list XRP. They had questions. They did approach the SEC about it. And after approaching the SEC, they concluded that it made perfect sense to legally list XRP. Apparently, they shouldn't have done that. Like, this is what I'm saying. They're clearly is not clear, or else you wouldn't have all of these actors in the space acting the way that they've been acting. Of course not. And anyway, Kevin continues. Ripple went back to court earlier this month to enforce a subpoena to depose Hinman in order to shed light on the agency's position on XRP. The SEC opposed the move on the usual grounds, arguing that Hinman had no firsthand knowledge of the facts and that the court should not open the door to routine depositions of high-ranking agency officials, even if they spoke publicly about positions that underlie enforcement actions. Deposing SEC officials on such a thin basis, the agency said, would, quote, disrupt the functioning of government, end quote, and deter qualified people from entering public space. And so, let me pause there. You know what my response to that is? Disrupting the functioning of government? Cool. I'll tell you what, if this disrupts people like Jay Clayton from pursuing positions at the SEC, then great. That would be fantastic, because people that operate in good faith won't have these fears. So yes, absolutely, proceed. Anyway, the court took issue with the agency's dire forecast, ordering Hinman to sit for the deposition. This is not a run-of-the-mill SEC enforcement case, the court explained, and therefore, Hinman's deposition would not open the floodgates. The case involves significant policy decisions on our markets. The amount of controversy is substantial, and the public's interest in this case is significant. And again, that's a quote. That's the court recognizing this, which is why during these pretrial hearings, I can't remember how many slots there originally were, but they had to upgrade the system. It may have been like, I don't know, it was like 100 or 200 or something like that. Whatever the number was, there was a very low limit to how many people could call in. And then they upped that number to 4,000. So the public, 4,000 people of the public can call into these lines. And every time there's been a pretrial hearing, even since the upgrade, the phone lines have been maxed out. 4,000 people on the call, and that's not enough. So yeah, I would say that the court's correct here in indicating there's sufficient public interest. Oh yes. Anyways, piece continues. Defense lawyers will find it hard to resist the conclusion that their SEC cases, too, far from being run-of-the-mill, present significant policy decisions that must be explored through discovery. Good candidates will not be difficult to find, since making policy for the securities industry is part of the reason why the SEC brings enforcement actions. Of course, this is only the start. The goal for defense lawyers is to build a predicate for persuading a court, as Ripple did, that the agency may be saying one thing behind closed doors and something else in court, requiring disclosure of the agency's inner workings. This project requires being alert to every circumstance that suggests inconsistent positions or lack of candor on the part of the government. It also requires hard work, the devotion of possibly hundreds of hours of investigation and document review, scouring the record for inconsistencies, which the Ripple lawyers obviously put in. The project may also require luck. Clarifying moments or epiphanies, like Hinman's speech, do not happen often. Without them, the defense has to try to accumulate enough details, calling into question the government's credibility to open up lines of inquiry that may bear fruit later on and support offensive discovery. Small victories sometimes can lead to larger ones down the road. Meanwhile, though, an aggressive approach has other rewards. Chipping away at the SEC's credibility can convince the court to shed its reflexive deference to the agency, which can be hugely valuable in an enforcement case, removing the invisible shield that protects the agency from the consequences of its own mistakes, a protection the defense almost never enjoys. Yeah, so that's a huge part of what makes this case unique, and that's what I was saying at the outset. Ripple's defense is rather intense. I would much rather be an attorney arguing for Ripple than be an attorney arguing for the SEC. That is most certain. Anyway, piece continues. Credibility attacks also put the government on the defensive, compelling it to devote time and manpower to running down claims, searching for documents, and formulating responses. And in addition, playing defense tends to be demoralizing. SEC lawyers, like those of any government agency, are accustomed to wearing the white hat. When they have to answer repeatedly for their erroneous or questionable representations, as the SEC attorneys in Ripple have had to do, they lose their focus. As one SEC lawyer complained to Judge Netburn at the hearing in April, defendants are trying to put the SEC on trial. Finally, an offensive strategy can create possibilities for settlement that otherwise would not be available. Although it is unlikely that Ripple is contemplating settlement now, when it does not yet know the SEC documents or testimony it will obtain. Ripple's ability to have the complaint dismissed without a full-blown trial is far from certain. Its success to date, though, has already put the SEC on the defensive and sensitized the court to the government errors and misstatements, intentional or otherwise. Both are significant tactical advantages in a closely contested litigation where the fate of the company may be at stake. Golf clap for you, Mr. Kevin O'Brien. Well said. It's just an interesting analytical approach to understanding what's going on within the case. And so, for all these reasons and many more, I'm very optimistic here. And so, Kevin, I've never heard of him before. He's clearly just coming at this from an unbiased perspective, and he can clearly see, just as we all can, that the SEC, they are putting out all sorts of false information. They do not appear to be acting in good faith, and it's adding up. You gotta understand, the judges that are handling this case, Netburn and Torres, they're human, okay? They're not stupid. They're actually highly intelligent. And they're going to know that the SEC's approach, if logic doesn't follow the words coming out of their mouths and the words that are printed on the pages that they file to the court, the judges can see that, just like any layperson can. And they have such a weak position that it's not hard. You don't have to cut much below the surface to see the whole thing. It's a facade. And it's unethical. It doesn't stand to reason, and I believe that history will show that Ripple's on the right side of history. And so even if they settle just to get this whole thing done and they end up paying a fine, whatever, as long as they can continue to sell XRP and XRP can openly be traded on cryptocurrency exchanges in the United States, to me that's a win. Call it whatever you want to call it from a legal perspective, settlement, whatever. You call it what you want to call it. I'm still saying if that happens, that's a win. That's a desirable outcome. But I'll wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.